Welcome to this online lecture, Resolving M&A Disputes via Arbitration. My name is Dr. Herald Sipple. I'm the Bali International Arbitration and Mediation Center's Academic Director, and I also act as a counsel and arbitrator in international arbitration proceedings. It's my pleasure to be here today and to do this session with you. As a note of caution right at the outset, please know that this is really just an introductory session. It is impossible in the course of only about 10 minutes to discuss everything in great detail. So my goal here today is to give you a great overview, but keep in mind at all times that it is only an overview. We cannot do the details, we cannot do the particularities. With that, let's jump into M&A disputes right away. Before we start discussing M&A disputes, we must first look at M&As as such. What are M&As? Everyone talks about them. M&As, when you look into a financial dictionary or also into a legal textbook, is a consolidation of A, companies, or B, assets. And all of this is done through various types of financial transactions. What are these financial transactions? It's a big term, but what really does it mean? We're speaking of mergers, so that's two companies coming together without one acquiring the other one. We're speaking of an acquisition of shares. We're speaking of an acquisition of assets. We're speaking of consolidations. And of course, there are numerous other types, but these are the main types. This is what's typically understood as M&As. When it comes to M&A disputes, and especially M&A arbitrations, there are quite a few people who also take into account other types of transactions. I'm not covering these here. I'm really focusing on the core of M&As. Why do we have disputes in M&As? Why do disputes emerge in the first place? Because it's such a hot topic. Everyone talks about it. Why do they exist? Well, first of all, there is an information asymmetry. When you are the acquirer, the company that buys another company or wants to consolidate, etc., it doesn't matter. You will usually know much less about the target company than the target company itself knows. So when you look at the financial statements, they may look perfectly fine to you, but in reality, there is a hidden issue, which you may or may not discover in the course of your due diligence. The point here is that the acquirer and the target have a different set of information. And usually the target's information level is about here, whereas the acquirer's is just here. So because of this information asymmetry, there are problems which arise. There is often a lack of understanding within the target itself. So even though I just mentioned that the target knows itself better and there is information asymmetry, sometimes mistakes just happen. There is a wrong entry in the financial statements, and this was not done intentionally. It's just a mistake. It's something which the target had done unintentionally. So the target itself is not fully aware of what's going on. And this may sound very basic to you, but trust me, it happens more often than it does not. There is often a lack of understanding or planning of the acquirer. And when you look at the cartoon I put on the slide, that's very often what happens. Just a lot of gobbling up with a lack of planning. There are numerous books out there describing M&A failures. And on average, when you look at M&As overall, there is a lot of evidence that they are not really successful on average. Finally, and this is becoming, unfortunately, more and more common, there is fraud. So this is why disputes emerge, but what types of disputes do we have? The most common type that's at least discussed about, remember most of this is confidential, so you wouldn't know. But most types which are discussed are guarantees, reps, and warranties. When you look at the agreement, especially now we're speaking about an acquisition where one company buys another one. The target company will usually make, or the seller rather I should say, will usually make certain guarantees, representations, and warranties. And when these guarantees, representations, and warranties are not fulfilled, and I'm listing them right now on the screen, then there's an issue. And this is when, at the end of the day, the target company will be valued lower. It's just worth less. For instance, because the target company says it owns a certain patent, but it turns out it does not. And because of this low valuation, there is then a dispute because the acquirer wants a reduction in the purchase price. Other types of disputes, which we see frequently in M&A arbitrations, are about tax covenants as well as fraudulent actions. I mentioned them before. And as I mentioned at the outset, this is really just an overview. There are a lot more, of course. I'm really just giving you the most common types. When we speak about particular issues in M&A disputes, what are those? What's peculiar about them and probably different from other types of disputes? More than often, there is more than just one party versus one other party. Often it looks like this. So you have 2 on one side and 3 on the other side. It can also look like this, 1 on one side and 5 on the other side. There are all sorts of constellations. The point here is that quite often there is more than just one party. Third-party funding plays increasingly a role in M&A disputes as well. So there is one company which funds the dispute. There is often an issue whether arbitration is the best format or expert determination should be used. And this goes hand in hand with the use of quantum experts. Remember, I mentioned at the outset that a lot of disputes are about the valuation of the target. So this means that there is a lot of need for quantum experts, a high need for quantum experts. And this is why they are very often used. And when you look at these are really features, all of which can be dealt with very, very well in arbitration. You add to that the fact that arbitration is confidential, and you will not wonder anymore why so many arbitration disputes so many M&A disputes go to arbitration and not to court litigation. Let me tell you a bit more about M&A disputes in practice, those which go to arbitration. The vast majority we see are not the the mega mergers and acquisitions. We're usually speaking about mid-size arbitrations. Why is that? Well, first, they happen a lot more often. The vast majority of companies is not listed on the stock market. The vast majority of companies is privately held. And it's normal that these companies change ownership more often. Also keep in mind that a lot of the issues that arise from the information asymmetry are much less prevalent in an M&A transaction where the target is publicly traded. When the target company is publicly traded, it means that almost all the information that's fundamental is out there anyways. All the financial statements are going to be made available to the public because that's a requirement when you publicly trade it. So the types of disputes we see in M&As are usually not the mega mergers and acquisitions, although they exist, of course. It's usually the mid-size M&As. Something we have also been seeing increasingly in the last year is cross-border M&As. And this is, of course, also a reason why arbitration is better suited. When you are an acquirer from India and you purchase a company, say in Germany, would you like to go to German courts? Of course not. You have to speak German. You have to get acquainted with the German court rules. You need interpreters, etc. It's a lot of a hassle. Arbitration can resolve that, of course. And this is also why arbitration is used much more often these days, because there is a lot more cross-border M&As. A lot of M&A disputes could be avoided if only the contracts were drafted well. This is very often the result of sloppy drafting. I've seen this over and over. I've seen it both in my capacity as an arbitrator and in particular in my capacity as a counsel. And that's very unfortunate, because it should not happen that a dispute goes to arbitration just because the lawyers who drafted the contract screwed up. And finally, that's my last piece of advice here. When you are involved as a transactional lawyer, make sure you get your arbitration clause right. A lot of the M&A disputes that I've seen were originally just about procedure. The term midnight clause is especially relevant when it comes to M&A contracts, because these are often contracts which are dozens or even hundreds of pages long, and the arbitration clause is very often not really important. And then as a result, it's inserted way after midnight on the day the deal has to be signed, because commercially everyone agrees. And this is unfortunate and should not happen. With that, I thank you very much for your attention. I hope you enjoyed it as much as I did recording the session.